let me ask a few questions of you, Yvette, that have come in generally about NFFE and your relationships with NTEU and AFG and other organizations, um, as well as whether you ever bring class actions where people think that their union rights are being infringed.
Yes, so through my office, again, people come together in difficult times. I am now in at least 4 phone calls with everyone within the community who's leading the fight on this litigation. So all the union general counsels regularly talk. I also talk quite frequently with nonprofit groups like Democracy Forward, who partnered with the law firm Alden Group to bring forth that OSC class action complaint, equivalent of a class action, that resulted in the MSPB stay that helped the probationary workers. And we're continuing to strategize around that. I'm also in regular communication with um, the uh, the Ninth Circuit court case that AFGE filed. Neffy couldn't be a part of it because we'd already filed another court case, but I've provided declarations and information that have helped Judge is it Alsup in the Ninth Circuit issue his phenomenal rulings supporting federal workers in this climate and bringing people back to work. So we're all in coordination. Not every union can be on every lawsuit. The way we started this out, it's been sort of a spaghetti on the wall approach because we don't know which circuit is going to be favorable necessarily, and different unions have different groups of employees that are suffering impact at different times. But I can assure you we are all in communication, and now I'm even happier to have Pride in Exile, this network, to be able to talk through. And I'm going to be talking to the ACLU one of these days as well, because I know they are very focused on protecting feds in this community. And I know from the union's perspective, if we're getting to a point where we can't get the recourse because there's a staffing shortage or some other reason blocking us from our normal track of getting a hearing or getting justice, that could be grounds to file another lawsuit, basically a class action. And that would be in coordination with all of these nonprofit groups who are so into protect democracy, citizens for we just have such a great community right now of literally like 60 of the smartest people that I've ever worked with, and none of us have ever been in this exact situation before, but we have the grace to hold each other and say, well, I know you know a lot about this and you know a lot about that. Let's get together, put our heads together, and figure out how we can help this suffering workforce that has done nothing but do their job, commit to the mission, execute the mission without asking for very much. And now they're just being pushed all over the place. It's disgusting. And I can just promise you that we are a broad community. Now you're plugged in to this broader network, and I want to be the glue or the conduit, however I can help this group make sure that your individual issues are being resolved through whatever resources we've got. Sometimes it's just knowing who to ask. So we've got that now. We're in community now, and I'm grateful for that. Hopefully that answered the question, Jocelyn. I kind of
No, it's very reassuring to know that we are all, I've forgotten the idiom, rowing in the same direction, using the same oar. We're in the same boat, but we're working together, and that's terrific.
Yep, absolutely.
And just another logistical thing, we are not answering any questions in the Q&A. Okay, again, this is sort of all various privacy pieces. And the raise hand function is not enabled. That's also sort of part of the privacy pieces. So you're getting to us through Jocelyn reading the Q&As or by sending an email.
So here's a question probably for Anisha and Hai. if someone accepts a severance package, does that limit their rights before the EEOC for EEO complaints or the MSPB or OSC? Anisha, you want to start?
Not 100% sure. Yvette might know, but I know typically in a severance, I can speak to the private sector on that. There is a release of rights, which also includes the right to file administrative complaints. So I would imagine, but I'm not sure if either of you know the right answer.
I have very strong opinions about the deferred resignation program. That includes a waiver of rights pretty clearly. And so we have advised and recommended, even though it's your own personal choice, that you take a good hard look at what you're waiving if you decide to invoke that offer of the deferred resignation program. Generally, if there's some other sort of severance package, I mean, there's VERA, the voluntary early retirement that a lot of agencies are starting to offer. Normally that does not come with any sort of waiver of rights. The other thing to remember is, and this is why the deferred resignation program offer was such a disaster and so terrible. There's no lawful way for an employee to waive their right to file an EEO complaint. You can never waive that right. Yet the deferred resignation program includes such a broad waiver of rights. You know, we could have challenged it on that basis, but instead we just told everybody, just please look at it and make the smart choice for yourself. So, you know, other severance packages, unless it's negotiated to try and settle a case, you know, that you might see a waiver of claims there. But again, you're negotiating. Hopefully you're represented in that negotiation. And you would make sure that you're not, you know, doing an overbroad waiver. Other things that might come with a RIF, no, you will not be waiving rights if you get RIFed. You will have multiple avenues to challenge the RIF, including on the basis of discrimination. That's what I know about those.
Quick question, Yvette, you may know the answer. Although you should be able to still file the complaint through the EEO process, are you foregoing your right for any compensation through that process? I know that's how it works in the private.
Shouldn't be. No,
Okay.
Yeah, you
I
know,
don't think you can ever waive damages, basically.
The right
well,
to.
you know what I would say to this? I mean, Pride in Exile is not going to be offering legal advice, obviously. However, we will take in some of these questions. I just remember this from being a commissioner. This was all often discussed, and Jocelyn actually was one who sort of took my seat at the EEOC. You definitely want to be careful and not be waiving your rights when you leave. So why don't we say we're going to take this back and see if we can write something in plain English and put it on the website.
Thanks. That is helpful. I am so grateful to this community because clearly a lot of you are very well informed about the federal sector processes, and we've gotten some helpful suggestions and input from people both in the Q&A and separately through the Pride and Exile email. And I don't know, Hai, if you are reading some of those hints through the emails, but I can just read some of these if you are not, so that people are aware of the kinds of advice that their colleagues are giving.
Yeah, no, why don't you read them and also put down that computer so we can see your full face for the recording. Thank you.
Sorry about that. Okay, so these are about the federal EEO process. The first tip is remember the 45-day calendar period begins when you discover or learn about the fact of discrimination. You may suspect discrimination, but the 45-day clock starts when you get evidence that discrimination has occurred. So if, for example, you didn't get the first promotion you applied for, and you didn't suspect discrimination, but then you discover something that ends up leading to a second denial of a promotion, that's, or to an understanding that the first denial was discriminatory, that's when the 45-day clock starts. So don't think that you're too late just because you had no way of knowing at the outset that what has happened to you was discriminatory.
Great. Let me add something to that.
Yes,
That's
please.
excellent. The second thing is if you're being harassed, it's from the last time that you were harassed. So if you started getting harassed 6 months before and it continued, but then you were harassed again, that's it. You can start your 45 days from that.
Right. Second, that be aware that typically a plaintiff agrees that they won't disclose anything they've learned in mediation, and that's a downside to going to mediation because it may affect your ability to bring forward evidence should the mediation fail and you ultimately end up having to litigate about your claim. So just something to keep in mind when you think about participating in a mediation process. Anything to add there, Hi?
Yes, I actually had that initially in my notes, although I was being very good on my timing. So good to say that ADR is completely confidential. No one can say anything about what happened, and that includes you if you ended up going to court. And nothing is agreed to in the ADR process in mediation until it is actually written down and signed. So thank you for that addition.
And one thing in the Q&A that people may not have seen is just the tip that after EEO counseling, which might be in person, might be on the phone, might be through a virtual conversation, or it could be in writing, you'll receive notice from the EEO office and the AJ as applicable about the time limits for going to court or for the next steps in the process. It may be buried in the notification that you get. So make sure, even though I am guilty of just, ignoring fine print and lengthy, dense government forms, make sure you read all of it to get all of the relevant information about next steps and what the time limits are.
And do want to add to that, that is true. It will be in what you get. However, you will also get these slides. And that's why there's a separate slide on your timing for filing a lawsuit and also all the other pieces of timing. But yes, that is the thing that is better for federal employees than folks in the private sector is that you can actually, when things are running well, do everything through the EEOC, AJ's commission, no lawyer, and you can get relief. And if you win, the agency cannot appeal that. That's the benefit you get as a federal employee. The minus that you have much shorter timeframes. Much shorter timeframes. And I will tell you, during my decade at the EEOC, one of my priorities was to change that 45-day limit. And I'm standing here today telling you, we weren't able to get that done. Annoying as hell, but at the least we can get this information out to you.